this.
Okay.
Because if we don't deal with capacity, there's no point in this. Yeah, and I suspect we already hit capacity.
No. We still got a bit of capacity, but we need to. There's no question we need to scale up. Absolutely, 100%. No question in my mind. Peter, do you agree?
Go. It's 10 o'clock, guys. Are you ready?
Yeah.
Okay, we on live. Let's just give this a moment for the participants to join. Whilst you do that, and make some introductions. We have Rachel on the right. She's from the IQ Business Group. We have, it looks like Paul Michael, but it's listed as Derek. I'm not sure what happened there, but that is Paul Michael. It's not Derek. Then we have Peter Gordon from Engaged. Then we have Ian Fleming, also from Engaged Business Turnaround. We have Dean Wright. He's a partner at Schindler's, and I'm managing partner of Schindler's Attorneys. So we're here today to discuss business rescue. We have already gone through the Act. We did so on Friday during our panel discussion, and that video is available on the Schindler's website, and it'll soon be available on other sites, including the COBRA site. So if you want to go through a step-by-step analysis of the Act with reference to case law and with reference to practical aspects of business rescue with reference to the provisions of the Act, please look at that video, because today what we want to do is we want to do a Q&A session where we take questions from the audience, and I've got a host of questions which I do know the answers of, but I'm going to get the panelists to answer it. So we're going to have a bit of a debate if a debate arises. So let's see, we have our participants have joined. I'm going to kick off, and I'm going to ask Peter, can you take us through what is meant by financially distressed?
Maurice, with pleasure. Morning, everybody. A company is financially distressed in terms of the Companies Act, Section 4 states that if the directors believe that the company is going to be unable to pay its liabilities as they fall due in the next 6 months, it's financially distressed. Just to remind us, if the liabilities then exceed the assets, it's classed as being technically insolvent. If both those are present, then that's when companies or boards of companies and senior management get very nervous because of the potential of being classed with reckless trading.
Yeah, I think this time, so just on that, just on the insolvency, I'm going to be jumping quite a bit, Peter, just to
cool, no problem.
Get the financial distress and the insolvency. I just want to explain to the audience, you have two types of insolvency. You've touched on the technical insolvency where your assets exceed your liabilities. But you also get commercial insolvency, where your assets exceed your liabilities, but you cannot pay the debts as they fall due. And that is the commercial insolvency, which the Act is designed to assist by giving you a reprieve so that you can see your way through the cash flow crisis and get back into business. Sorry, Peter, as I said, I'll be jumping in, but go for it, carry on.
No problem. So thanks for that, Maurice. And then what they did is when they, in the 2008 Companies Act, they introduced Chapter 6. Chapter 6 is very clear. If a company, it only has to meet the one criteria. The company cannot see its way clear to paying its debts as they fall due over the next 6 months, then the directors can declare the company is financially distressed. And in those circumstances, it is the first test of can the company, or should the company apply, not can it, should it apply for business rescue?
Yeah, we've got it here. So I've pulled the definition up, I've highlighted it. And yeah, reasonably likely it'll become insolvent or it cannot pay its debts. How does one initiate a business rescue once one falls within the definition?
Maurice, two different routes. The directors can take a resolution It's a 5-minute resolution. It states that we are financially distressed. However, and importantly so, we do believe that there's a light at the end of the tunnel, that this company should survive. And if it's given a reprieve and a moratorium, the directors firmly believe that this company can pull through. And that's an important point, because the directors actually have to sign or appoint one of their members to sign a sworn affidavit to that effect, and giving, not in huge amount of detail, but giving the reasons why it's in distress and why the company believes it's rescuable, if I could use that word. And that has to be filed at Sub-C. So it is then in the domain, public domain. And on that basis, with that resolution and then a form, a Sub-C form that needs to be completed, it gets filed at Companies House, and immediately on filing, it is in rescue. Some of the practitioners believe that you've got to wait for the stamped forms to come back from Sub-C, but generally they're not too bad. They will return them within a couple of days, but obviously under the current circumstances, there is a Sub-C document that's come out stating that all rescues are basically on hold at the moment because they're not receiving documentation. Off the record, we have been advised by one of the senior people at Sub-C that if the company files the documentation by way of email, that they're unlikely to reject that as an application for rescue once this moratorium, once the delay period is over.
Yeah, and I think what's also important there is just to explain to the audience that one is obliged to put business rescue to the vote at a board level the moment the company is financially distressed. So in the moment the board perceives a financial distress, and the threshold is pretty low, particularly in these circumstances, they're obliged to put it to the vote. If the vote goes against business rescue, so the board resolves not to put it into business rescue, they've obviously given it some thought and they have their reasons. So they have to, in terms of sub-7, if the board has reasonable grounds to believe that the company is financial, but the board has not adopted a resolution, the board must deliver a written notice to each affected person setting out the criteria in section 128. So you have to put it to the vote, but you don't have to vote in favor of business rescue. If the company is distressed, it's in your interest as a director to do so. But the COBRA environment has given you that reason to not put the company into business rescue, because the idea of the COBRA environment is to have the COBRA mediators try and mediate a solution as between your creditors and then in turn your creditors. So there's this cascading effect to avoid a business rescue. So you can say, well, we're in the COBRA environment, we're going to not put the company into business rescue to allow the COBRA consultants to assist us in avoiding that. If, however, it has to go into business rescue and the process follows, and we'll go through why and possibly you ought to put it into business rescue now, aside from the fact that you want to come into the COBRA environment. But once you're in the COBRA environment, you have the reason, and bear in mind that most companies at the moment are in fact financially distressed in terms of the definition, and that's simply because the future is opaque. This is going to affected person. I think we jumped that, Peter. Affected persons, we've got the definition here. It's a shareholder, registered trade union, and their employees. This also becomes relevant in relation to other provisions in the Act.
The thing to recall on the affected persons is it is essentially a creditor-driven process. So the creditors are normally the main affected people. Staff are also affected. Bearing in mind that as staff work for a company, you're incurring a liability towards them each day, not only from daily work, but also because of leave pay accruals, etc. So they are creditors of the company at any one time. So they, together with the broader body of creditors, and creditors is obviously trade creditors, it's your bank, it's shareholders if there are loans in the company, it's directors if they put loans into the company. But affected people and include shareholders, but the shareholders have a lesser say in the business rescue plan. It is the creditors that have to vote on the plan. So they carry quite a strong boat in the process of the implementation of the business rescue plan.
Yeah, and I think at this point you may just want to give some insights into the practicalities and the dynamics. So at the moment you get appointed, what does one do with the employees and what does one do with the creditors? I think it's also important for you to deal with the nature of the relationship and the fact that EQ in essence is required. Peter?
No, absolutely. I mean, certainly at Engaged, we are fairly, this is one of our cornerstones. And that cornerstone is we try and negotiate and work with rather than against. What you always find, 9 times out of 10, is creditors coming to that first meeting, which the practitioner is required to preside over. And obviously they're quite acrimonious because they think they're not going to get paid. And there is a bit of a stigma with rescue that it equals liquidation, which of course is not the case. So it is important in that meeting to be open. There's a complete transparency as much as required by the Act. Obviously, you're dealing with business issues here, so your competitor might be sitting at the room because he might also be a creditor. So one's got to be practical on that level from a business point of view. But it's all about collaboration and trying to work with rather than against. We do have the adage that if we start having discussions with the creditors through lawyers, notwithstanding the moratorium over any legal action against the company, that it's almost a failure on our part. Not always easy because you've got conflicting desires and conflicting needs and conflicting aims. Shareholders might be against directors. I've had a case where the directors are against the company, which was a bit tricky. So in those situations, you've got to obviously resort to the law to get advice within Chapter 6, but also still try hard and develop with the skin of an elephant to try and work with everybody, even though very often the practitioner is getting abused from left, right, and center.
Sure. I'm just going to mention to the audience that you can also put a company into business rescue by way of a court application. I'm not going to go into detail, just so the audience is aware that's generally when it becomes hostile. And if a liquidation application is launched, you cannot then resolve to put it into business rescue. You're going to have to deal with it as part and parcel of the liquidation. And what generally happens is you counter apply for a business rescue. So that's how you defeat an application for a liquidation. But we won't go into that detail. Yeah, Ian, over to you, just the time frames.
So Maurice, thank you very much. From the time that the company is put into business rescue, the company then has 5 days in which to notify all creditors of the fact that it's in business rescue and to appoint a business rescue practitioner. So the business rescue practitioner typically gets appointed 5 days after the company goes into business rescue. It's then incumbent upon the business rescue practitioner to hold the first meeting of creditors, which has to happen 10 business days after his appointment. Now, we call that a Section 147 meeting, and a Section 148 meeting has to happen at the same time, or it normally happens at the same time, and that's the meeting with employees. And the purpose of those 2 meetings is broadly to inform creditors and employees that the business rescue practitioner believes that there's a reasonable prospect of saving the company or of giving creditors a better return than they would get in a liquidation scenario. So that's what happens at the first creditors meeting. It's not very onerous upon the requirements of the business rescue practitioner in that meeting are not very onerous because he's effectively only had 10 business days in which to assess the company and form an opinion. But then 25 days after he's been appointed, he needs to publish a business rescue plan. And the business rescue plan is basically like a business plan that sets out exactly how the practitioner intends to turn around the company, return it to a solvent going concern, or in the worst case, wind it down under business rescue in order to achieve a better return for creditors than in a liquidation scenario. The 25 business days, which is effectively 5 weeks after being appointed, the business rescue practitioner has to publish the business rescue plan. Once he publishes the plan, he then has 10 days in which to hold a meeting, which we call the Section 151 and Section 152 meeting. And at that meeting, the creditors vote on the plan, whether to adopt the plan or whether to reject the plan. let me just go back to, so that's the broad time frames, and within the business rescue plan, it will set out how the plan will be implemented. One of the things that needs to be in the business rescue plan is 3-year projections as to what the company's financial statements are likely to look like, be it month by month or year by year for the next 3 years, whether or not the company is in business rescue during those 3 years. So let's just go back to the publication of the plan. It has to happen within 25 days after the business rescue practitioner is appointed. In reality, in big companies, this is often not easy. In small to medium-sized companies, it is sometimes quite simple because 5 weeks is typically enough for a business rescue practitioner to get his head around the plan, around the company and around the company's challenges and so on, and work out how it can be fixed, and then just to put that on paper and publish it as a plan. Section 150 of the Companies Act does deal explicitly what needs to be in a business rescue plan, and the requirements are fairly extensive. But it's nothing that any company shouldn't have available and that the business rescue practitioner shouldn't be able to access. So after 5 weeks of being appointed, if the business rescue practitioner is not able to publish a plan yet, then he'll typically ask for an extension for the plan to be published. And we've just seen that happening in the SAA case, where because of a complete fundamental paradigm shift in the economy and the environment in which the company is trading, they've asked for a 2-month extension in which to publish the plan. And in that case, it was actually the right thing to do, because if there are fundamental changes in the company that could affect the outlook for the company, as in the case of SAA, then to request an extension is the correct thing to do. But the timelines prescribed in business rescue are fairly tight. There's always a sense of urgency in business rescue, and this is important because everything is really urgent. You know, the company needs to be saved. People need to know where they're going. Creditors need to know how much they're going to get paid. Employees need to know whether they're going to have a job or not. And therefore, the timelines that are prescribed by the Companies Act are fairly tight and need to be adhered to as much as possible by the PRP.
I see there's a question here from an audience member. Publication and notice requirements in terms of Chapter 6. Should these notices publications take a specific form or be published via a specific forum?
There's no requirement for them to take a specific form, Maurice. Yeah. You know, we have standard forms. We generally try to keep them as simple as possible, but all the information that needs to be in them is in them. Although keeping it simple and keeping it as affordable as possible for the company is very important.
Yeah, I just want to mention, so a business rescue plan can be complicated, but I'll give you a case in relation to a restaurant that was in Camps Bay, and this is how simple a business rescue can be. What we did there is we put the restaurant that was really suffering because it was kind of below water, winter, bad market. And we put it into business rescue. You had a business rescue practitioner appointed. The business rescue practitioner went straight, obviously met with the employees, said, look, this is the plan. Went straight to the landlord, said, look, this is what we need. We need a remission and rental. Landlord said, fine. It was out of business rescue and the company had been rescued. Now that's kind of, there are going to be quite a few of those in the present climate, because that's what's required. It's really, it's about the cash is low. We're not getting the same income. We cannot afford it. So come to the party and reduce yours, and in turn with your creditors reduce those, and it goes all the way up to the banks. And the banks have already indicated that they are happy. So the difficulty when it comes to business rescue, and I'll go into the moratorium now because it's quite important, is that a creditor is the one who will force a business rescue. If a creditor is hostile, then you'd have to go into business rescue to get this moratorium, which I'll deal with. So it's not in the interest, it's not in anybody's interest to be hostile if you're a creditor. Rather deal with it in a pragmatic way. If you don't trust the debtor, pull the debtor into the COBRA system so we can then audit what the debtor is saying. Business rescue in this context is really just a leveling of the playing fields. The bargaining power is, if there's a disparity of bargaining power, somebody has a claim and they say, we can liquidate you. The moment you say, well, I'm in business rescue, the playing field's leveled. So what's the moratorium? Yeah, yeah. The
moratorium. I agree. And I think, just following on from what you're saying, I think the extent to which creditors do become hostile in this environment is really going to be determined by how hostile their creditors are. I think there's a complete new level of understanding that's going to emerge from this entire COVID-19 disaster, in that, you know, people are going to really learn to work together, and I hope that we are going to be able to assist with that in getting debtors and creditors to work together and to understand each other within the COBRA ecosystem. But yeah, at the end of the day, the creditor is only going to give his debtors reprieves as far as his creditors are giving him reprieves. So depending on, you know, everybody throughout the chain, you know, right up to the IMF and the World Bank have their own creditors. You know, so it all depends on the extent to which their creditors are pressurizing them.
I have a question which actually was raised by Peter last week in one of these webinars. You'll see it, Peter, it's addressed to all the panelists. What happens if many creditors are based outside of South Africa? In other words, online services paid by credit card. And we actually had a case where the debits were taking place. So if you want to go into that, Peter, you'll recall it, you mentioned it last week.
Just help me, Maurice. What was the, I didn't quite understand the question.
One of the questions that was raised last week is, what do we do? Because we're going to Business Rescue, they're still going to take the money off the credit card payments. So the question here, you'll see, what happens if many creditors are based outside of South Africa? In other words, online services paid by credit cards, etc.
Right.
And the two aspects of the question is, what happens if we need them? Okay, so we need the services. And then the second question is, what happens if we do not need the services, but the debit order is taking place regardless? And the company's in business rescue.
I think the first important thing is that any contracts have to be placed on hold immediately. There is a process for doing that in terms of the Act. And all suppliers have got to be advised that contracts are being halted. You've got to be careful of that, because as you rightly say, some of the contracts, you've got to be very careful in deciding what's critical and what's nice to have.
Tommy, can you go in there if this does happen as business rescue practitioner and ask the bank to freeze the account so the debits do not go through?
It all depends on the nature. If it's a direct debit or a standing order, the different rules apply. But I mean, what will often happen with the banks is, as soon as they're advised, and in fact the practitioner can ask them to, is to freeze the bank account. So the bank account is frozen. Obviously, all debits, be they standing orders or direct debits, will be returned to the supplier. But I mean, the critical thing here is, and it's not only with things that have been going through on direct debit, it is essential to decide fairly early on in your investigation of which of the suppliers are critical. If you in a manufacturing business and you want raw materials, obviously that supplier, I mean, Ian and I are dealing with one at the moment. There's only 2 suppliers of a particular material in this country, and both of them are exposed to the business. So you've got to go and be very open with them and try and negotiate a process whereby they continue to supply you, notwithstanding that their credit balance that was outstanding as at the date of rescue has been frozen. And the practitioner is not allowed to prefer one creditor over another. Important point, because very often a creditor will say, well, just pay me, I'm a small, and I've heard practitioners say it, they're just the small creditors, let's pay them and get rid of them, get them out of our hair. Well, you're not allowed to do that. All creditors, as you said, Maurice, the playing field has been leveled and the bar has been set. So you can't prefer one creditor over another unless you bring that creditor, what we call, into the rescue. And if you bring in a creditor into rescue, it is an essential supplier. And then you can negotiate with them how you're going to treat them going forward as opposed to pre-rescue. And just to remind us that going forward, anybody that's providing funding, whether that's the banks or creditors or staff for that matter, to the company post-rescue, you can offer security. The practitioner can offer security. So if there's assets available in the company, you can go to a supplier and agree with them to continue supplying them, but provide them with some security over the assets of the company. But, you know, there's an old adage, and it's been around for a long time, and in any rescue, cash is king. And a practitioner's got to be very careful about what he hands up as security, because at the end of the day, he might be having to sell company vehicles merely to pay the staff. So it is critical to very quickly understand where the cash is going to come from and how you can manage that to the best interests of the survival of the company. Because as I said earlier, whilst
you can also deal with, Peter, sorry, whilst you're responding, sorry I interrupted, post-commencement finance, because that's relevant also to your answer.
Yeah, look, I mean, it is a reason that a practitioner could, because remember that a practitioner has the power, if he or she believes that this company cannot be rescued, he or she has the power to put it into liquidation, and indeed is obligated to do so. You can't just hang in there forever and a day hoping that the sun's going to shine tomorrow. And even if the directors disagree with that decision, obviously, as I said earlier, you would try and work with them to convince them. But really, if the guys have got their head in the clouds, then, you know, and you see there's absolutely no hope. Now, in that sort of scenario, it is quite critical then that if you can't get what we call PCF, post-commencement finance, that will very often lead to the liquidation of the business. Post-commencement finance traditionally would come from, well, your first port of call is always the shareholders. Shareholders stroke directors, family, friends. If it's a small business, is there somebody that puts some money in here merely to keep the thing going, whatever that means, paying the staff, buying raw materials, keeping the production line going, etc. If you can't do that, the practitioner's you're in a catch-22 situation. But as I said earlier, what you can offer is any assets in the business as security, normally with the banks. I think Ian was saying the other day on another webinar that we don't have a sophisticated distressed debt market. So there are not many people in the market who are prepared to put up funding in a distressed environment. They are there, but they tend to be extremely expensive. Expect to be paying over the 20% interest rate. And if you can afford that, that's fine. We use discounters a lot. Discounters will, you know, continue discounting invoices against reasonable end risk, i.e. proper customers that you sell, or credit worthy customers that you sell into. Excuse me, but
maybe I can pick up there quickly, Peter.
I'm just losing my voice. Please continue, Ian.
Yeah,
okay.
If you just also deal with preference, Ian.
Yeah, certainly. So it's important to note that if the business rescue practitioner or the company raises post-commencement finance while the company is in business rescue, and that is secured post-commencement finance, then should the company go into liquidation for any reason, then that secured post-commencement finance ranks right at the top in the liquidation. So that creditor will be repaid first before anybody else.
I think what's important there is to pause, and this is very, very important for the audience, is we've had a lot of people putting in money to pay, let's say, staff salaries outside of rescue, which means that money that you're putting in, you'll be rendered a concurrent creditor in relation to those monies. However, if you were to put the company into business rescue and then lend the money to the company in business rescue, you get the super preference. So it's a no-brainer. Definitely work with COBRA if you intend to put money in, to put the company into business rescue, and even out if it's needed, but just to get that super preference.
Absolutely.
You'd rank above the South African Revenue Services on the super preference. However, on liquidation, if it's converted to a liquidation, you lose that preference. So that's always something to be mindful of. Just whilst I'm on liquidations, if a business rescue fails and there's a conversion to liquidation, that takes, the only way the practitioner can do that is by way of a High Court application. Now that application costs in the region of about 30,000 rands. COBRA will be doing those applications pro bono for businesses who cannot be rescued. We see it, the way we see it is if you've got to pay 30,000 rands out of your own pocket, it's actually the pro bono relates to you personally, so that you don't have to endure that expense at a time of need. So that's covered.
Maurice, I just want to clarify something for the audience. Make an important point there, because I sit on the SICA, the Institute of Accountants, as does Ian, and we've got a subcommittee for business rescue practitioners. And we have spent a hell of a lot of time talking about this very point, because what can happen to the detriment of business rescue practitioners is the company is failing. You're left with this, disaster to sort out. You decide liquidation is the only answer. And the practitioner is then called upon to put the company, as you rightly say, Maurice, and then the practitioner can be called upon to pay for the High Court application. So, the fact that Schindlers are doing this on a pro bono basis through the COBRA plan is a fantastic concession to practitioners as well as to the companies, because what the practitioners have started doing is saying to the company, fine, I hear you want to go into rescue, please can you put 30, 40, 50,000 Rand into trust with my lawyers to pay for the liquidation application as and when it occurs. Now, for goodness sake, you're going into rescue, and if you're a smaller business, you don't have 30, 40, 50,000 to stick into a trust account. So it is an important point for the smaller companies of the concession that you're offering through COBRA.
And nobody likes to pay for a service in advance of the service being delivered, especially in a distressed environment. So, asking for a deposit up front can really be onerous on a company when they haven't even seen the extent to which the business rescue practitioner can assist them. Can I just, sorry, Maurice, before you move on to the next point, I just want to quickly, just for the audience's benefit, just to clarify what we were saying about secured post-commencement finance. If it's secured, when the company goes into liquidation, if it goes into liquidation, that finance ranks at the top. So they are still super preference in liquidation if it's a secured post-commencement finance creditor. What changes is that the business rescue fees and disbursements that are owed to the business rescue practitioner, if it goes from business rescue, the business rescue fees and disbursements are super preferent. If it goes into liquidation, then that falls right to the bottom. Then the business rescue practitioner's fees and disbursements become a concurrent creditor effectively. One more point on post-commencement finance providers in this country. As Peter pointed out, in America, for example, the opportunistic distressed funding market is very evolved, very established. There's a lot of funds that invest into distressed businesses for above average returns. In South Africa, that is still a very immature market. There's only one or two players in that market, one that we know and that we know quite well. Typically, the providers of post-commencement finance to business rescue companies are companies of financiers that already have a stake in that business, that have already taken risk in that business. In other words, either the banks or the shareholders and directors. That's one reason why it's important to have a good relationship with the banks, at least enjoy a relationship of trust with the banks and the country's key finance providers of finance, private equity funds, and so on.
I'm going to pick up on a question.
Sorry to interrupt you there, Maurice. Just another interesting point. Ian and I are currently dealing with a listed company, which it's just gone into rescue. And the JSE rules, first of all, the company can apply to have its shares suspended. You don't have to. And if the shares are still listed on the exchange, there's nothing to stop a listed company going to the shareholders by way of a rights issue to raise capital. And there are quite a few people that are prepared to do underwriting of that issue in order to make sure that your rights issue doesn't become a damn squib. So that's another route if it is a listed company. I mean, I know COBRA is aiming more on the means test to the smaller companies, but the larger companies as well. You can raise money from the shareholders through a mechanism such as the JSE.
Peter, I think it's important to point out, sorry, Marisa, I know you wanted to talk. I think it's important to point out at this stage of the game that COBRA targets all companies and not only the small to medium enterprises. Obviously, the smaller enterprises are the ones that are going to benefit from the pro bono services, in that we only charge fees to the extent that, so in other words,
so the idea is to render a business rescue successful. If fees are the impediment, that's the means test. The impediment itself means that it has to be pro bono, otherwise it goes into liquidation. If, however, it's a cash flow issue, let's say 3 months, and the company is very, very, very solid, that would be different because you wouldn't pass the Law Society's means test. But COBRA is primarily aimed at actually helping them, those that require pro bono, who require the discounted fees to save their businesses. I just want to go to a clarification question from Carl. He raised this, earlier, what happens if many creditors are based outside of SA? He then follows on by saying, my question is more about jurisdiction and what SA rules would apply to companies outside of South Africa. So if I start paying for a service that I've committed to pay, can I tell the US, for example, Creditor that I'm in business rescue? The answer is yes. So just on general jurisdiction, the American creditor has the right to sue you in South Africa. There is jurisdiction to sue you. If the creditor decides to take action against you, then you put the business into business rescue. But importantly, you get the business rescue practitioner. He has to suspend the contracts. So the business rescue practitioner will be notifying them. It won't be you, notifying them saying, look, the contract's being suspended. You cannot carry on any further. So the claims, the legitimacy of the claims are affected by business rescue, but whether they'll care, who knows? I mean, what we were dealing with last week was debits taking place in circumstances where they knew that they were unauthorized, but the foreign company did not care. So it depends on your relationship there. But I think there are ways and means, particularly with the American companies, to put pressure on them with all the regulations that they have in relation to dealing with international companies. There's probably something there to say, look, they can't act contrary to the laws of a particular jurisdiction, and they would be doing that.
An interesting question there would be whether when the creditors' balances are frozen as at the commencement of business rescue, whether those foreign companies' creditors would be denominated in rands or whether in foreign currency. And our answer to that is they would typically be denominated in rands, despite what the contract says. Yeah, it's just something to think about.
I've had that exact case. A South African lent money into a company offshore from his offshore trust, and you can't actually put it in foreign currency because it's a moving target.
Exactly.
They're trying to do a business rescue plan which says what people are going to be paid, and because of the way the rand has gone over the last few years, you've got one creditor whose balance keeps increasing each day that you're working. It's not appropriate. So what I did is I fixed it as at the date of rescue, as you do typically with interest. I mean, it's just another interesting aside. You can freeze interest. You've got to go and advise all the people that are requiring interest. This was a financial services company, and you freeze interest on all loans, and rescue what is the capital. And obviously, in a rescue situation, a lot of companies are just delighted to get their capital back.
Yeah.
I just want to touch on, and maybe kind of out of context, but I don't want to forget, and that is a lot of questions also arise in relation to labor. What would you do with the staff in a situation like this? In business rescue, the rights of the staff are not diminished in any way, and the provisions in the Companies Act apply. Just making a note here.
While you're thinking, Maurice, just on that point, obviously it's important to note, Maurice, 100%, all rights still apply, but the practitioner can go through a downsizing process in terms of the Labour Act and do redundancies. The only person that the business rescue practitioner cannot remove without going to court is the director of the company.
Yeah, so quite correct. So the question remains then, what in these peculiar circumstances, what has changed in relation to, let's say, retrenchments? And what labor lawyers have, the view that they've adopted is that the procedure for a retrenchment in terms of Section 189 of the Labour Relations Act is, in all probability, can be curtailed because one need not consult on certain aspects, such as the reasons for the proposed dismissal. I think that's common cause. It would be common cause. So the consultation would be limited, but also operationally, the curtailment of the procedure is necessary. And we believe that there's a good chance that our labour courts and the CCMA would recognise that when it comes to a curtailed procedure. So as a business owner, be alive to that. And if you're going to pay salaries, I've mentioned it, it's very important, only do so by way of post-commencement finance. Just whilst we're there, because what would happen is if the retrenchments were to take place in business rescue, it would be the business rescue practitioner who would make the decision. Now, just, yeah, and if you can deal with the relationship between directors and the business rescue practitioner, the directors remain as directors and they have their duties. But now you come in, and what do they have to or not have to do?
Certainly, Maurice. So yes, the directors still have their fiduciary duties throughout the business rescue process. However, the directors report to the business rescue practitioner. So the business rescue practitioner has ultimate control of the board. Now, this is very, very important when choosing, when making the decision about who your business rescue practitioner is going to be, because the last thing you want is a business rescue practitioner who comes there, kicks the CEO out of his seat, and thinks he knows everything and just does his own thing. We always say that we will never, as BRPs, have the same relationships with the company's suppliers and with its customers and with the public at large as the board of directors has, or as the proprietor has, the guy who started the business 20 years ago. We will never have the relationships. We will never know as much intimate knowledge. We will never have the intimate knowledge of his business that he has. Therefore, we as the business rescue practitioner are there to come to guide you through the process, to hopefully get you out of the business rescue process at the end of the day, to hold your hand, and to work with you. That's why the choice of the business rescue practitioner is so critical and fundamentally important to the success of the business rescue at the end of the day. Experts will tell you that the choice of the BRP is 99% what results in the success or failure of the business at the end of the day.
There's a question. What's the success rate of business rescue?
Success rate of business rescue in the industry, in the country, sadly is below 10%, actually. We've been fortunate enough to achieve a much higher success rate than that. However, if you look at the success rate in general, if you compare it to America, in Chapter 11, if you ask what the success rate there is of Chapter 11, it's also not fantastic. It's below 15% by most estimates. So another thing that's important in line with that question is to define what is success, actually. What constitutes the success of a business rescue plan? Is it, A, the return of a company to a solvent going concern? Is it giving creditors a better return than they would get in a liquidation scenario? Or, and this is what we perceive success to be, if the business rescue plan is carried out, is implemented in line with what the business rescue plan foresaw for the company. And that is how we define success of business rescue. Sometimes in a business rescue, and we're very pragmatic when we assess these companies and we put business rescue plans together. We realize that some companies can simply not be saved. Some companies simply cannot be returned to a solvent going concern. We had an example last year. A company had 150 million rands worth of liabilities and it had 50 million rands worth of assets. Now, with the best of intentions, with the best skills on the face of the planet, there was no way we could get into that company and return it to a solvent going concern. In other words, close a 100 million rand hole within a period of a year or two. It's simply impossible. It's taken 5 years, probably very difficult to raise post-commencement finance in that case. So what we did is we put together a plan that envisaged the winding down of the company under business rescue. Creditors ended up getting 35 cents odd in the rand, whereas in a liquidation scenario, they probably would have got 10 cents in the rand. So very important, and we consider that to be a successful business rescue in that case. In a company where the whole is a lot smaller, where it's only factually insolvent to the extent of maybe having assets of 30 million rand and liabilities of 35 million rand, then there's more than likely a reasonable prospect of returning it to a solvent going concern. We'll give it every chance that it possibly has. We have to be pragmatic when we look at it. We have to look at it. If the hole is simply too big, then there's no point in trying to save something that is already dead.
That's a question by Carl. He's asked, does Engage BT turn business away if they see that they cannot turn the business around? I think the answer to that is no, they won't turn it around. They may be able to do a wind down in circumstances where they're going to be cheaper, their fees are cheaper, and the sale won't take place by way of a forced sale and liquidation. So most of the time, there's a better return to creditors if it remains in business rescue. If it goes into business rescue, remains, and there's this orderly wind down. Liquidators' fees are set by way of a percentage depending on the class of assets. It's 3%, 6%, and 10%. So if you have listed shares and they're worth 100 million, it's just a straight percentage for one sale, which is unfair. It can be reduced if you complain to the Master of the High Court.
Thank you.
Whereas a business rescue practitioner charges by way of an hourly rate. So if you can't save the business rescue is still appropriate.
The fact of the matter, can I jump in there very briefly? Just one thing to say. The fact of the matter is there's very few instances where we cannot give creditors a better return than they would get in a liquidation scenario. So the direct answer to your question is it is seldom that we turn businesses away. The times that we do turn businesses away is when we simply cannot work with the directors, and there have been instances where we've come across directors who are reprehensible individuals. Sorry, I don't mean to say bad things about people, but we do come across those instances, and we turn those away because we simply cannot work with them.
Yeah, sure.
Just a couple of things just to add to Ian there. We must remember, and anybody who wants the stats on business rescue, there are graphs put out by SIPC. If you just search for SIPC business rescue statistics, you'll see the numbers of what's in and what's out and what's gone into liquidation. Very few rescues have gone into liquidation, which is an interesting point because the success rate is very often because companies have gone into rescue merely to delay the inevitable. And there are some very good cases on this in the courts where the courts have ruled, normally application by the banks, who are normally the secured creditors. I'm talking about property development by and large, or property owning businesses, where the courts have overturned the rescue and placed it into liquidation. But Maurice, a question that often gets asked to me: how do we identify if a company is rescuable, and beyond just doing a structured wind down, which Ian's covered? And my view on that is, as long as there's a market for the company's product, and as long as they're able to produce for that market and deliver service or product to that market, then it's rescuable, because that's what it's all about. It's about continuing to sell into a market, making money from your services or product. And if you've got those two, then we should be able to raise capital to rescue the business. So beyond that, anything is possible. I dealt with one a few years back where it was a hopeless case. I had a company with a property on its balance sheet at 750 million rand. I had it revalued at 380 million rand. It was a complete fraud. It was a company that had offered financial instruments to Sharia-based investors. I had 300 Sharia investors, all from pensioners to wealthy. I had a couple of advocates in the portfolio. They were baying for my blood. They wanted this thing put into liquidation. And I said earlier, you develop a thick skin, because all I did is plowed on, and the property is being developed as we speak. It should return something in the order of 1.2 billion, and all the creditors will be paid over an extended period. So what I did is issued a financial instrument, in this case a debenture, where the investors were converted into a secured debenture. So if the rescue didn't work, they would still be able to realize their security. But the fact of the matter is that this didn't have a hope in hell if you looked at the balance sheet. And another point, and I'll say to Ian, you never say never, because this was a case. I had 5 directors. I ended up, as I'm allowed to do, working with the finance director and completely sidelined the other 4 who were up to no good. They had been the ones that had defrauded the investors in the first place and are under investigation by the FSCA as we speak.
I just want to also mention that if you launch an application to go to court, and this is really on Carl's question, what if you cannot turn the business around? If you launch an application to court, there's a case, Southern Palace case, where Judge Eloff said that you actually have to demonstrate to the court that there's either going to be a better return to creditors or that you have a plan in mind. And there's another case involving business rescue where what happened was the court actually ordered a wind down in the order and said if this does not work, as opposed to business rescue, if this does not work, then the company must go into liquidation. It involved the Emperor, which is a apartment block in Santon City. We have a question going back a bit. Well, what happens if the creditor does not receive notice within the prescribed 5 days about the company going to business rescue? Ian?
Maurice, typically how the courts have seen this in the past is that, if the business rescue practitioner, if he was acting in good faith and it was just an oversight, then it's okay as long as the creditor was notified eventually and as long as he wasn't prejudiced. And I think that's what the courts have in general looked at, whether or not a creditor was prejudiced by any non-compliance with the time frames prescribed in section 1 to 9 especially. So what happens is that if he wasn't notified, if it was an intentional act by the practitioner not to notify him, then that's a very serious offence, and the practitioner should be removed for that reason. If it was simply an oversight and the creditor was not prejudiced, then the creditor would typically just point it out. The creditor would typically point it out, have found out by some other means that the company was in business rescue. He would point it out to the practitioner, and the practitioner would then go put him onto the emailing list or whatever and inform him of all meetings and so forth going forward. But if the creditor feels he was prejudiced by not being notified, then he needs to go to court, whether he feels it was an intentional act by the business rescue practitioner or whether he feels it was just an unintentional oversight.
I was going to go back to my comment earlier just around PCF, around the order of preference, because you correctly clarified that, but I think there remains the question of whether the order of preference applies to a creditor who didn't vote in favor of the plan. I think the law there, it hasn't been decided, but the law there would, in my view, favor there being a preference, but we were about to take that to court and the matter settled. The question was going to be dealt with by the court. We had wound up to the point of appeal, but there is a chance that the appeal court would find differently.
Yeah, there is a chance, absolutely. In the interest of fairness, in the past, we've always treated it as treated all creditors equally in terms of preference, whether or not they voted in favor of the plan. But yes, that is an interesting one to debate.
I think we've covered.
Maurice, just one thing on the question that Ian was answering about if a creditor falls off the list. Two important things there in the early days, because we've got 5 days to advise the creditors, is to interrogate that list with the company, because the company bizarrely often forgets who creditors are. So a company will often come to us, certainly small and medium companies come to us and say, here's my list of trade creditors. And then you say, have the shareholders given loans? Yes, I gave money. So they're a creditor. Have the directors given loan? Has the family? So you start interrogating and you start adding up. I mean, Ian and I had one last year, which unfortunately put into liquidation because it's one Ian referred to, there's no hope in hell. But the creditors almost tripled through our interrogation of what were the creditors. But if they missed off that first meeting, remember that first meeting is only there to do 3 things. It's to explain to the creditors how Chapter 6 works, exactly as we're doing here. How does the business process work from a time limits and legal point of view? To explain briefly why the practitioner thinks the company has gone into rescue, to give details of the sworn affidavit that the directors have already filed at Sub C, and then most importantly, the practitioner is obligated to make a statement to the creditor body that he or she firmly believes that the creditors are going to do better in rescue than they would do in liquidation. Underlying what Ian said earlier, that liquidations generally you're going to get a lower return, but not always. And the practitioner does have to apply his mind to that. and at every step of the process has to ask that question. So for example, if the plan hasn't been filed or voted on, published and voted on within the time limits, the practitioner is obligated to do a monthly report to sub-C and to all the affected parties. And in that report, he specifically has to say, I continue to be of the belief that a better return is achievable. And that is an important fact, certainly on those where practitioners sitting on his laurels and just eking out a subsistence out of this failing company. Because if it finally goes into liquidation, believe me, a liquidator is going to have a field day by proving that there was no hope in hell, but this guy kept trying to keep it into rescue. And we have had examples of that, so we mustn't expect that that doesn't happen.
Great,
The
thanks
point
for that.
is, if there's been any administrative slip, all the practitioners, so, you know, a creditor was missed off. A creditor can be missed off at the voting time. Now that would be sad because that's minimum time, you know, a month in, just over a month into the rescue. If you're still missing creditors there, that either is because of complete skullduggery on behalf of the company, or it's somebody that hasn't stood forward themselves. And if that is the case, then you can rectify that in the plan. And your plan will normally have a clause in it saying, notwithstanding, for example, that the notice to creditors went out a day late, creditors, by accepting this plan, accept all rectification of prior administrative mishaps.
Great. I see there are no other questions. Let's make sure. I think we've covered the important aspects. I don't think we've covered post-commencement finance. We've covered the moratorium. We've covered the labor aspect. If there's anything, please post your question.
One question that I see is there, which I discovered earlier, is when does the company go into rescue? It's the point at which the resolution, together with the sub-C form, Core 123.1, is filed at company's house. At that point, the company's in rescue. As practitioners, we like to get that form back stamped and received by sub-C, but that's not a requirement. It's merely the email filing of that resolution, the sworn affidavit, and the Core 123.1 is the company's then in rescue.
Yes, creditors will, and especially the banks, will typically only consider you to be the appointed business rescue practitioner once the CRPC forms to put the company into business rescue have been stamped by the CRPC, and once your appointment forms as the business rescue practitioner have also been stamped and dated by the CRPC.
I'm just going through the Act to see if there's anything that we have not dealt with. No, I think that's that. Section 154 basically is the discharge of all debts and claims, and it says a business rescue plan may provide that if it's implemented in accordance with its terms and conditions, a creditor is acceded to the discharge of the whole or part of the debt owing to the creditor will lose the right to enforce the relevant debt or part. There's also an aspect that we were taking to court is in relation to the accession. What happens afterwards? So there's the vote has gone through, the creditor hasn't acceded. Now what? Have you dealt with that? Yeah.
Yes, Maurice, this is quite specific to sureties, and it's the same discussion we were having yesterday. So yeah, so what and then the wording of the surety, whether the creditor can pursue the personal surety or the guarantor, as the case may be, while the company is in business rescue, depends almost entirely on the wording of the surety document. Some surety documents will preclude the creditor from going after the guarantor until the stages of the business rescue process has been completed, and there is case law to this effect. The reason for that being that the value of the claim cannot be quantified until the business rescue process has been completed. So if the value of the creditor's claim is R1 million, and the business rescue process foresees that the creditor is going to be paid R1 million, then obviously then the reason for the court's decision is that the creditor can't go after the surety because of the fact that he's likely to be paid in full according to the business rescue plan, but at the end of the day, he doesn't know how much he's going to get. So the value of the claim under when pursuing the surety is uncertain. So the court ruled that the business rescue process has to be completed before the creditor could go after the surety because of the quantification of the value of the surety claim.
Maurice, just to elaborate on that, sorry, Maurice, just to elaborate on that point a bit. I mean, and I'm sure there's a couple of lawyers listening in. If a client comes to me, a potential rescue, there's some basic questions are asked. Firstly, are there any liquidation applications that have been lodged against the company? Because if that is the case, then the company cannot go into rescue until it sorts out those applications. You cannot go into rescue while there's an outstanding liquidation application against the company. Number two, have any suretyships been signed by the shareholders or directors or staff, as Ian's saying, because that can change the whole nature of the desire of the directors, owners to go into rescue. Because if you know that you're going to still lose your family home, then you're going to try and recover as much as you can in the business by continuing to trade. Highly risky, contravention of Section 22, trading whilst under insolvent circumstances, reckless trading. One's got to be very cautious of that. But you know, that aside, I think those are two very important questions, because the third question I always ask is, if the bank is putting pressure on the company, who are you dealing with? Because if the company's still dealing with a relationship manager, then things should be fine. Second, they could be dealing with the business rescue units, the recovery units within the banks, which is good news to us because Ian and I have a very good relationship with all the major banks and those units. And to be honest, a lot of the banks often say to us, thank God you're on board, because we can't trust anything we're getting from this company. But if you're already in the hands of the bank's lawyers, then I would argue it's almost too late, because the lawyers in the bank are just interested in they have an adage, first lost is best lost, and what they want to do is put the company into liquidation and recover their security. So these nuances of where the thing is vis-a-vis the action by the creditors that would help you decide whether this thing is able to, i.e. no liquidation applications, or should go into rescue, i.e. where is it with the banks. If it is already in the hands of the bank's lawyers, then it is quite critical to appoint somebody, and as I said, Ian and I are close to the banks, who can go into the banks and negotiate with the rescue and recovery unit to get that case moved back into that unit, because those guys are there to make sure that the business survives so that they get their money back. They're not hell-bent on putting this thing into liquidation merely to recover their security.
Fantastic. Thanks, Peter. We're done for the day. We've 2 minutes past 11. I've got to run. I've got another meeting. I thank the audience. Remember, there is the video on the Schindler's Facebook page that goes into more detail, or just join other seminars. We're going to have seminars that are more specific on aspects of the business rescue. So we'll put notices out on the website in relation to those. Otherwise, contact us if you want to arrange a private meeting between Schindler's, let's say, and your team as part of the pro bono services to walk through the specifics. So just contact me or send an email to info@cobra.org.za. Great. Thanks, guys. Thanks, everyone. Cheers.